Yes.
Mr. Mishcon, I've just a few questions I've been asked to ask you arising out of your evidence this morning. So these are questions that have been raised by core participants to the inquiry. You'll recall we discussed before lunch your and Ms Boyd's February 2014 letter to the Secretary of State and to the Charity Commission, to whom you sent a similar letter. Do you recall why the Charity Commission declined to become involved?
No, I don't. I don't think they gave any particular reason, but I may be wrong on that.
And then I asked you about the work of the Working Party looking at the position of widows. Was any particular consideration given by that Working Party or by the board, to your recollection, about the position of those who were bereaved and were also HIV infected?
If they were HIV infected, they would have been personal sort of PBs, primary beneficiaries. So they would have received the same regular payment as other primary beneficiaries.
So is this right, that there was no expectation, might not be quite the right word, but expectation that the widows in that category would move on?
No, I don't recall that ever being suggested.
You referred in your evidence this morning to Mr. Evans, in his capacity as chair of the trust, having his own agenda. What did you mean by that? What did you understand his agenda to be?
What I think I meant by that was that whatever Mr. Evans thought should happen was to happen, irrespective of the views of trustees. It is not, in my understanding, the role of the chairman to row his own boat. It is for the board of trustees, who have the ultimate responsibility, individually and collectively, for the general control and management of the administration of the charity. And they comprise the board. When it comes to making decisions about the charity, it's for the trustees to make them together, not the chairman off his own bat.
The message comes across in your written statement, and I think possibly in your oral evidence too, that the trustees of the Macfarlane Trust consistently were concerned that the annual Department of Health allocation would be withdrawn or materially reduced. What was the basis for that concern? What was said or done by the Department of Health to give rise to it?
Well, I didn't have discussions directly with the Department of Health, but it was the feedback from the chief executive and the chairman that in their discussions with the Department of Health, because of austerity, because of cutbacks in budgets imposed by the Treasury, that there was the possibility of a reduction. I don't think it was ever discussed that there was, well, not to my knowledge, that it was going to ever come to an end, but the annual allocations only started happening before my time as a trustee, but I think it was only at the around 2002. I may be wrong. As I said, it's a long, long time ago. I mean, before that, there were capital payments, but no annual allocation.
I asked you earlier about empowerment and empowerment grants. To what extent do you think that the objective to provide empowerment grants for educational or business development purposes was achieved?
Well, I can't answer that directly. I think what I would say is that the availability of these grants was advertised to the beneficiary community, presumably, and I have to say presumably because I don't know for sure, through the newsletter and the website, and it all depended on who applied. As my recollection is that there were very few applications.
Did the Trust ever give any consideration during your time there to other ways or possible ways of facilitating empowerment? So rather than simply waiting for people to apply, perhaps organising events, training and the like directly?
Not that I recall.
Turning then to the use of the reserves for the work on home capital payments that you referred to before lunch, can you assist with this? What investigation was in fact undertaken by the Macfarlane Trust into the extent of the need for home adaptations, aids and equipment?
Well, as I recall, the survey went out and over 200 people responded positively to it. Some of the applications were regarded as a little over the top in terms of the amounts involved without any real clarification. As I recall, but again, my recollection may not be correct, there were visits that were made by an independent company, and decisions were made in relation to a lot of those applications. I mean, favourable decisions, I should say.
And then if we can look at a document we looked at this morning, Shomik, it's MACF 5025_009. These were the minutes of the special meeting of the National Support Services Committee in November 2011 that we looked at. If we go to the second page, please. And we look at the top half of the page. We looked earlier, Mr. Mishcon, at your proposal or your working party's proposal in relation to the use of the reserves. We can see here a proposal by Mr. Dolan to consider the issue of underwriting insurance for death, mortgages and travel, to also consider ring-fencing some of the reserves to cover the possible loss of DLA to primary beneficiaries. Do you have any recollection as to why that proposal was not apparently taken forward?
Looking at the proposal by Mr. Spellman, inquiries were made of insurance companies, as I recall, even for a relatively small amount of cover, but it was, I mean, the premiums that were being quoted were out of all proportion. As for Mr. Dolan's proposal, this is a question of the charity underwriting, and I think it was felt, I don't know if this went to trustees, sorry, this is a board meeting, isn't it? So it would have been discussed by trustees, and it was felt that this was not what a charity should be doing. This was for the government to do, or the whatever, or Department of Health. Other countries did have a method of, I think it was Ireland, if I remember correctly, whose policy was that if individuals could get insurance, and this I think also included travel insurance, that if there was an uplift in premium because of their HIV status, the government would pay that uplift. But if it wasn't possible for them to get insurance, the government there would underwrite it. But it was not something that was followed by the UK government.
May I just correct something you said there? You referred to this as a board meeting. It wasn't. My understanding is these are minutes by the NSSC.
Right.
It was a special meeting of the NSSC, but it was the NSSC. So does that make any difference to your answer?
It doesn't, but thank you for pointing that out, Sir Brian.
Did the McFarlane Trust ever lobby the government during your tenure to try and introduce some form of either in government contribution to insurance or government underwriting of insurance?
I can't recall if it was in any business plan. And I'm not aware of anything specific.
We can take the document down, thank you. And then in relation to appeals, so appeals to NSSC and appeals to the board, what information about either the procedural requirements for an appeal, whether new evidence was required or the like, or the basis of an appeal, what information was provided to registrants? Do you know?
I do not.
Was any help provided for appellants in the presentation of their appeals?
I'm not aware of any, but I would have thought that the support services staff, who I can only commend, or the ones that I was working with, and that's Ros Riley and Keisha, had a double-barreled name, I'm sorry, I can't remember it, from my knowledge of how they dealt with cases, and sometimes I was in the office when they were speaking to registrants or beneficiaries, that they were always as helpful as they could be. The objective was not to prevent appeals going forward, but to help people with making representations to the NSSC, and if you're talking about an appeal to the board.
And were reasons provided to an applicant if the appeal was rejected?
I presume they were, but it wasn't part of the NSSC's remit to, as it were, write to those who had applied to give them reasons. I'm assuming, but it is an assumption, that the support services staff would have given reasons. Assuming, of course, that the committee gave reasons, which I think that they did.
Well, we can no doubt check that from the records, Mr. Mishcon. And then penultimate question is this. I asked you this morning about whether any particular consideration was given to those parts of the bereaved community who were not widows, so children and parents by way of example, and I think your answer was to the effect that you don't recall any particular consideration being given. Is this right, that the trustee didn't create any particular hierarchy of relatives? Was any consideration given as to whether treating widows in one particular way and other members of the bereaved community in another way, whether that was consistent with the trust deed?
I think that the support that we gave to widows had additions for dependent children. I cannot recall if there was any hierarchy. I don't think that there was.
Final question. It's come across clearly in your evidence and I think reflected in your dissertation that you felt that distributing funds to registrants via a charity was an inappropriate response to what had happened. For the benefit of those listening who will not necessarily have read your dissertation or indeed your statement, could you just explain for us why that was your view?
Well, charity trustees have very strict requirements by law in what they can do with charitable monies, and that all comes back to financial need. if a trust had been set up, not a charitable trust, by the government into which funds had been put, and I'm thinking of the thalidomide trust that was set up actually by distillers, to which the government subsequently made contributions. A trust then has completely different powers, which would be determined by its trustee, but doesn't have to follow the legal requirement of financial need as a charity does.
Thank you. So those are the questions.
Can I just say it would have been far better if the government had made payments to beneficiaries direct, rather than setting up this MFT. I used the word cushion in another context, but it really did create a barrier between the beneficiaries and the government, which was clearly beneficial to the government or the Department of Health. And that meant that instead of the government or the Department of Health getting stick from beneficiaries, MFT did.
Thank you. So those are the questions I have that I propose to ask from core participants.
Well, I've got a couple of questions which I'd like to ask. And the first really arises out of reflecting on what you had to say this morning, in particular by reference to your exhibit, that's witness WITN 4274002. This is your letter, together with Ms. Boyd, to Jeremy Hunt as Secretary of State.
4474. Sorry, so for the transcript, I think it's 4474002.
Thank you. Thank you very much. This is essentially a letter which complains about the way in which Roger Evans has exercised his chairmanship, is it?
Yes, Sir Brian.
And earlier you said to me that one of the first meetings under his chairmanship, that would have been the meeting in I think 2012, you drafted a letter to the Department of Health, which you invited other trustees to consider with a view to sending it to put pressure on the department to pay money, and that caused a certain amount of vigorous debate, to say the least, amongst the trustees, and ended up in Mr. Evans expressing the view that the trustees were fractious and dysfunctional. You recall that?
Yes, Sir Brian.
Now, how against that does your evidence that the trustees were generally a cohesive body sit? Because it must be quite unusual for both the chair to describe those who are trustees as dysfunctional and fractious, and a couple of the trustees who, when they leave after lengthy service under a variety of a number of different chairs, write in order to complain about the chairmanship of the current chair.
Well, I don't agree with Roger Evans' view as to the board, but it does go to my sort of feelings that if somebody didn't agree with Mr. Evans and what he wanted to do, he expressed his dissatisfaction with them. Maybe dissatisfaction is the wrong word, but he chose to ignore those views.
So was the board truly cohesive at that stage?
It wasn't always at one, but then you wouldn't expect a board of so many trustees always to be in agreement, but a board of trustees has to look at issues and come to some sort of conclusion. And I've always felt that the majority view must hold. If a chairman chooses to exercise what I might refer to as undue influence, then I don't think it's appropriate. And I'm recalling the letter that was shown to me earlier today, which talked about the DOH appointees virtually having a duty to support the Department of Health on this.
So, was it your view that he was exercising undue influence?
Well, with comments like that, there is a suggestion of undue influence. I think I would put it that he was ignoring opinions which were contrary to his.
Well, if that was the case, how could the trustees operate except as a rubber stamp?
Well, I hear what you say.
Well, it's a question.
Well, I don't think we did act as a rubber stamp. It's quite clear from my evidence that I had contrary views as to how the trust should go about its business in order to comply with my understanding of charitable law, and that I had wanted individual assessments, whether that was carried out through the census or some other practical way. And clearly, I was not in the majority and therefore had to abide by the decision of the board not to go down that route, but to continue paying out regular payments irrespective of financial need.
Now, can you help me with this second matter? This relates to the legal advice which was given by Pesners to the trustees on their development day and subsequently. You think that the advice was had at least 3 different iterations to make it more comfortable for the board, in there, at least they hoped it might. Did you ever see that legal advice?
Yes, I have seen it. I'm not sure that I saw the first 2 because only the third one was provided to the Board of Trustees.
And did it seem right to you, in the sense of legally correct, probably?
Well, I think, Sir Brian, you would have to see the other letters, and there was also some correspondence. I asked for and received it from Russell Cook, the firm of solicitors who all the papers of the Macfarlane Trust were given to, and I was told that I wasn't to divulge those opinions without the consent of the Skipton.
Well, I'm not asking you to divulge it, but it's really a question of your reaction to it, which you presumably remember, whether you thought, oh, this is absolutely correct, it's obvious, or whether you thought, well, I'm not sure about this.
Well, I thought that the first opinion was very accurate and good. The final version was, I will use the word, watered down.
Now, throughout this period, you were in practice as a solicitor.
I still am.
Yes. And tell me, is that for Mishcon?
No, not presently it isn't. I'm a consultant at Mishcon, but I'm also general counsel to 2 companies.
So Does Mishcon have, amongst those who work for it or are partners in it, have individuals who are knowledgeable about trust law, and in particular that part of trust law which involves charities?
Very much so, sir.
So it would have been open to you, had you wished to do so, would it, to have gone and chatted informally to one of your colleagues and said, well, I've just got this problem, can't give any particular details except these details, and you could do it in a way which didn't breach confidentiality, I'm sure, and find out their opinion.
With respect, Sir Brian, the Trust took the opinion of Berwin, Leighton, Paisner, an equally reputable company, and I didn't see it as appropriate. I was aware, and I've said this in evidence today, that the chairman of the Trust, Christopher Fitzgerald, did not share my view.
I'm not saying that you should have done it, but if there were grounds for seeking a second opinion, as there might have been, if you're right, you might have asked to say, well, can we get a second opinion? I'm not sure that this is correct.
Well, Sir Brian, the advice that was given was that certain steps should be taken. And with that, I fully agreed. So the fact that those steps weren't taken in full, time sort of moved on. So I can't really see why you're asking me why I should have taken a second opinion.
Well, part of the reasoning is this. This really involves Miss Richards. We have a copy of the trust deed as it was in 1988. So far as you are aware, Mr. Mishcon, was the trust deed that you were considering during your early trusteeship, and possibly your later trusteeship, was it still the unamended 1988 deed? Do you know?
I honestly can't recall, Sir Brian.
Well, that's why I thought you might be able to help, Miss Richards.
So there were multiple amendments, I'm afraid, and we didn't provide this to Mr. Mishcon.
No. Well, in that case, I shan't pursue this line of questioning, but I think in due course it might be worthwhile looking at those and letting them be disclosed to core participants if they haven't already been. What I have in mind is simply this, that Clause 4 of the original trust deed makes no particular reference to finance. It makes reference to needs, and plainly it envisages that financial needs will be amongst the needs, but it does not necessarily, in its apparent wording, restrict the scope to financial need. If that be so, there may be a question whether any other principle of charity law or charity statute might affect the position.
We can,
I leave it there.
yes, we can certainly look into that, sir. I've got in front of me the text of the original version of Clause 5, and then the 2012 amendments, which introduced an idea of financial assistance and other benefits and charitable need. But what I don't have, and certainly hasn't been provided, are all the iterations in between.
Well,
so I wouldn't want to be saying anything about it.
Well, I was aware that there had been a number. It is, I think, Clause 4 in the original, not Clause 5.
Yes, it's by the time it gets to what I've got from 2012, it's certainly Clause 5. But,
yes. And the words charitable need do come in later to later drafts, as I recall, from documents you've already shown me. But I don't want to trespass in an area where there are various amendments about which I haven't been fully informed, and I'm in no position to draw any conclusions at all, just raise questions.
No, and we didn't trouble Mr. Mishcon with those documents.
No, well, I can understand why. I'm sorry for troubling you with that last point.
Mr. Brown, I only would want to add one thing, if I may. I refer to the definition of need at page 16, again, of my dissertation. And where I say halfway through that, from a charity law perspective, however, need refers to financial need, and there is a footnote which says trustee information pack prepared by Berwin Leighton Paisner, November 2006 at para 2.2. I don't know whether that helps you, but
well, it only helps me to know that that Paisner said it. It doesn't help me to know how correct it actually was. But I shall leave it there.
Thank you, sir.
Those are the questions. Mr. Mishcon, do you have anything you would wish to add?
No, I don't.
Well, it remains for me to thank you very much for fleshing out a lot of the information that we have about the way in which the Macfarlane Trust in particular operated during the years that you were a trustee of it from 2006 through to 2014. And your insight into the way in which the personalities worked together or not on the board is fascinating and informative. And I'd like to thank you for that and for your thoughtful exploration of some of the principles which lay behind the viewpoints which you took and expressed. Thank you very much.
Thank you, Sir Brian.
So we'll have Mr. Murray next, but we'll need a break in order to set up the link.
Yes, we must make sure that this link is working
yes.
Efficiently from the start.
Yes, I think 10 minutes is usually enough, but it might be safer to
Well, shall we say 2:45?
Certainly.
2:45.
Thank you.
Thank you very much, Mr. Mishcon.